Good afternoon, viewers and listeners. You have met again on the Community and the Law program with BWF Solicitors. Today we are asking ourselves a question, and the question is, can a mother who does not live with her child rely on that child to make an application for leave to remain in the UK? The answer is yes, and these are the reasons. First, you have to prove that the child is a qualifying child under Section 117D of the Nationality, Immigration and Asylum Act 2002, which states that a qualifying child is a child who is under 18 years of age and is a British citizen or has lived in the UK continuously for 7 years or more. If we're able to prove that the child is a British citizen, the child is a qualifying child. Or if the child is not a British citizen, but you can prove that the child has lived in the UK for 7 years or more, the child is a qualifying child. Having established that the child is a qualifying child, you move to the second stage to assess whether you have direct access to that child. The reason is that you do not live with a child, and therefore, on what basis are you saying that the child is your child and you want to rely on the child to stay in the UK? You prove that you have direct access to the child, based on which you want to be able to continue to support the child's development. What is direct access? Direct access simply means that you play a role in the life of the child, and therefore you have a shared responsibility for this child. Being a parent with parental responsibility, you also have a role to play in terms of the welfare of the child, financial support, emotional support, psychological support. So how do you prove this in fact? You show this by having evidence from the child's father to confirm that you play a role in the life of the child, and therefore both of you take care of that child, even though the child does not live with you. You also can use GP letter confirming that you are named as a person who can be contacted in an emergency situation, and therefore you have a role to play in the child's life. If the GP can also include the fact that you support in bringing the child to the GP for appointment and you are always in the child's life, that even adds weight to that. You also can rely on a letter from the school. If you can't get a GP letter, you can rely on a letter from a school the child attends to prove that you are named as a responsible adult for emergency purposes in the life of this child. The school can also attest that you sometimes take the child to school or pick the child up from school. This is important to prove direct access. You also can rely on a court order if it's a formal arrangement that has been ordered by court. In this case, you need permission from the court to be able to use this document. In that case, you do not need a letter from the father. And if you do not get a GP letter or a school letter, that court order suffices. We have been able to assess these two limbs: the qualification of the child and your direct access to that child. If you are able to prove all this, then you will be granted 2.5 leave to remain in the UK to be able to continue playing a role in the life of the child as far as the child's growth and development are concerned. This is a discretionary application, and therefore you are proving that a refusal of your application will be harsh and will bring untold hardship on this child, and therefore you should be granted to be able to be there for the child. Therefore, when making this application, this is what you have to look at. And if you're a mother and you do not live with your child, you now know that you can rely on this child to make application for leave to remain in the UK. We hope we've been able to answer the question in a way that will help you to make an application of this nature. Join us again next week for another episode. Thank you.